Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Fernanda Suriani, and this is the first panel on the second day of the event. I'm very glad to be here with you. Before I start the panel, I'd like to thank our sponsors. Our platinum sponsors are JUS Brazil and Albert Einstein Israeli Hospital. JUS Brazil is currently the #1 law and government website worldwide with 28 million unique users each month that makes high-value legal information super easy and quick to access, thus saving its users time and providing substance for their case strategies and insights. Albert Einstein Israeli Hospital, our other platinum sponsors, is one of the best-known health units in Brazil and Latin America for the quality of care and for the equipment and medical specialties available to treat main types of pathologies. The hospital is referenced in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and research activities. We also have to thank as our gold sponsor, PG Lawyers, and as our silver sponsors, Oasis Open and Obsi Bloom Lawyers. So now I'd like to introduce you to Mr. Wachara Wacharakorn, who will present the full paper with the title on semantics-based minimal revision for legal reasoning. Ms. Wachara from Japan, the stage is yours.
So I share the screen. So thank you very much for your introduction and greetings to you all. So this work is a work that I work with Assistant Professor Kaneji Shima and Professor Ken Sato, and we are from IAAIL and Sokendai in Tokyo, Japan. So this presentation is divided into 4 sections and shown here. So let's go, let me give some background of this work. So in this work, we consider the problem that the literal interpretation of statutes may lead to counterintuitive consequences. Which are the counterintuitive consequences are the consequences that do not meet the social expectation and the consequence occurs since the social expectation is evolved or exceptional cases happen unexpectedly in real life. So this kind of consequence cause absurdity, strange behaviors, or leads to public interest if the consequence were not properly handled. So judges, especially in high courts, may handle this kind of consequence by considering the exceptional situation of the case and make a legal judgment known as the case law that divides the interpretation of the statute to handle the exceptional situation. So in this work, we consider minimal revision. This is one common criterion from the standard revision theory. We reset it to adjust theories as little as possible. So minimal revision can be divided into 2 main types. The first type, as we call syntax-based minimal revision, is to keep the set of rules as close as possible to the original one. So this type of minimal revision is independent from the facts of the case. And the second type is a semantics-based minimal revision, which is to minimize the change of the set of conclusions obtained from the theory. So this type of minimal revision depends on the facts of the case, since different facts give different sets of conclusions. So although the syntax-based minimal revision is benefit from the independence of the facts of the case, we argue that the semantics-based is more preferable in legal listening. Since legal listening is a hybrid listening between rule-based listening and case-based listenings. So therefore, we propose here one kind of semantic-based minimal revision called a dominant-based minimal revision. So this solves some problems in attempting to develop a semantic-based minimal revision. So let me give some settings of this work. So in this work, we consider a normal logic program also known as a log program for representing the schedule as its many previous works. So a normal logic program, or hereafter a program in short, is a set of rules in the form of head, if, the bodies, where the body is divided into two parts. The first part is the positive body, and the second part is the negative body containing the negations, where the negations here, it shall be interpreted as negation as failure. So in civil litigation, a judge would make correspondence between factual situation in the case and factual concept in schedules. Then the judge would conclude a legal decision based on the schedules. So to reflect this civil litigation, we determine propositions into two types. The first type is rule proposition, and the second type is fact proposition. So the fact domain is a set of all fact propositions in the language, and the case is a subset of the fact domain. So we define the fact base and the rule base as shown, and we get that the answer set is the set of conclusion from the union of the fact base FB with a rule base RB. So this represents the literal interpretation of the statute, which is represented as RB when applying in a particular case that's represented by FB. So we denote a proposition P is in the answer set of FB union RB by FB union RB derives P. So exceptional case is the case that the judge disagrees with the literal interpretation in the case, and the judge introduced a new factual concept to distinguish the case as exceptional. So we formalize the agree and disagree as follows, saying that FB union FB1, the fact that FB1 union with the rule base RB1 agrees with the fact that FB2 union with the rule base RB2 on some proposition P if is derived in the same they derive in the same manner, or they do not derive P in the same manner. So otherwise we say that if B1 union RB1 disagrees with B2 union RB2. Is to extend the body of the new rule so that it influences the dominant rule base as least as possible. For example, if we suppose we would like P is as a culprit and we add not R in the first rule, then the way to make minimal revision is to extend AC the new rule as R if AC instead of R if C. Then we get only two revision that only two changes that in the rows.
Mr. Bhattacharya, 5 more minutes, please.
Right. So given a CCR task, let me illustrate with the working example that given a CCR task of JRB1, JRB1, which is the rule base that represent Japanese Civil Code Article 612, and this talk about the cancellation of the lease contract due to the subleasing without permission, and this to prove that the cancellation due to sublease, we need to prove four requisites. The first one is the list contact must be effective. The second one is the sublist contact must be effective. And the third one is the listing use. And finally, the cancellation is manifested. In this one exception, that is sublist has been improved before cancellation, then cancellation due to sublist shall not be valid. So this effective contact has one rule R2, but the effective sublist contact suppose that there are two rules R3 and R4. Yeah, so there are two types of effective sublist contact. And this one exception rule about the approval of sublist here in R5. And we have the exceptional case that have this kind of six facts, which literally make cancellation due to sublist to be valid. But the judge indicates the facts about non-destruction of confidence as an extra fact, and would like that, and did not intend that cancellation due to sublist to be valid in this case. So the cancellation due to sublist is our counterintuitive consequence here. So one way to revise to have the solution of this is to add new exception, while the new exception is derived from non-destruction of confidence, the extra facts. However, we get that this JRB2 will make a necessary change to the dominant rule base of the relevant case that with the both case of sublist, a second kind of sublist, since it will execute the exception as shown in this table. So another solution is as shown that instead we have the new rule of exception that derive from these three conditions. So when compile this kind of rule base and fact base and execute this dominant rule base, we get that the dominant rule base of this kind of this JRBT does not make unnecessary change occurring in JRB2. JRBT is actually a dominant base minimal revision. Usually, this new rule for the new exception box other type of sublist and allows only the type of sublist that relevant to the present case. So let me have the conclude of this presentation that in this work we propose a dominant-based minimal revision. This is a kind of semantics-based minimal revision, and this solves two problems in attempt to develop semantics-based minimal revision. One is this is not required to calculate the set of all conclusions for each case and is unaffected by the fact domain extension. And in further, we would like to develop effective algorithm for finding such minimal revision and make applications for other types of legal representation and other type of revisions and application for the case where the revision impacts several rules. So we hope that this minimal revision may lead to impact analysis in legal formalisms and may contribute to improving coherence in law. So this is the end of the presentation. Thank you very much for your attention. I look forward for the question. Thank you very much.
Thank you, Mr. Watara. Well, it's a very interesting presentation. Thank you for your contribution. And we have a question for you. It's how your research relates to the research on revision of normative systems and database updating.
Thank you very much for the question. So the question contains two parts. The first one is about the normative reasoning. Since this is some kind of preliminary research on this kind of revision, we have the setting that it talks about the setting is about a normal logic program, but we also consider that to extend one way to extension, as we mentioned in the future work. So one type of legal representation that we are interested in is the normative reasoning, so the reasoning and so on. So this is one consideration. And for about the database updates, I'm not sure what kind of database is mentioned. So, but we in this context, we consider the concept of debugging that extend from the how to say the expert system, the legal expert system that have been have been interested in around 1990s and so on. So that kind of talk about the debugging of this legal expert systems, and one of our previous work is to investigate this kind of legal debugging, as we call, and that may be related to database update in such scenarios, but I am not sure for the second question. I hope that just thank you very much for the question.
We have another question, Mr. Botara. It's from Trevor Bent Capone. Your example contained no variables. Can your technique handle logic programs with variables? These are widely seen as necessary for representing in law.
Yeah, thank you very much for the question. It's my honor. So we hope that so this in this setting we use propositions as Sir Benkapon had mentioned. So in variables, we also hope that we thought it in basically, but we didn't mention. We didn't have formalized it yet, but we think that so we extend some kind of scenarios with variables, but we didn't. Let's believe that we haven't formalized it in concretely yet, but we think about it. So we have think about it. So maybe it's not a good answer. Sorry.
Okay, thank you very much, Mr. Botara. Now I will introduce you. I would like to introduce you, Ms. Alice Witt, who will present the full paper, Converting Copyright Legislation into Machine Executable Code, Interpretation, Code Invalidation, and Legal Alignment, from Australia. Well, the stage is yours, Ms. Alice.
Thank you, Fernanda. And I just wanted to check that you can see my screen. Yep, okay, I'm going to proceed. Oh, great, thank you. Okay, so hello, everyone. My name is Alice Witt. I'm a postdoctoral research fellow in the School of Law at the Queensland University of Technology in Brisbane, Australia. And it's a pleasure to be presenting the full paper that I've co-authored with Associate Professor Anna Huggins, Professor Guido Governatori, and Joshua Buckley. So this paper presents what is, to the best of our knowledge, a first of its kind experiment that aims to shed light on how different legally trained people interpret and convert Australian Commonwealth legislation into machine executable code. So first, I'll briefly provide some background information, and then I'll explain why we focused on Australian copyright law. Next, I'll outline our experiment design and methodology, then some results, and I'll finish up with some concluding remarks and, of course, questions. So first, I just wanted to situate this experiment within the burgeoning Rules as Code movement, a label for diverse initiatives that reevaluate how, when, and for whom government rules are made. So there are two main Rules as Code approaches to date. The first of which involves converting existing regulation, including statutes, into machine executable code so that computers can read it and then use it to carry out programs. The second approach involves co-drafting regulation in both natural language and machine consumable format at the same time to enable computers to model the effect of the law. So while decades of research inform these overlapping areas, and countries including Australia, New Zealand, France, and Canada have made significant inroads with the practical Rules as Code movement, challenges persist in ensuring that encoded rules are transparent, traceable, appealable, and what we focus on in this experiment, legally accurate. So against this backdrop, last year, we commenced a multidisciplinary and collaborative research project that seeks to identify the legal and the coding challenges of converting Australian statutes into computer code, research that largely falls within the first rules as code approach, given that we're focusing on existing legislation. So the copyright law experiment that I'm walking you through now today falls under the third phase of this broader research project. So please do look out for our forthcoming publications relating to our other encoding exercises. So, as mentioned, the focus of this experiment is on copyright law, a body of intellectual property that confers rights in relation to the reproduction and dissemination of material that expresses ideas or information. So specifically, participants interpreted select provisions of the Copyright Act 1968. Periodically, I refer to this as the CA or the Act. And as part of this, we focused on literary, dramatic, musical, or artistic works known as Part 3 works. So we focused on copyright law for several reasons, including our research team having some copyright law expertise, and because this body of law is widely applicable to a range of stakeholders, but often difficult for lay audiences to understand. In practical terms, our research could be of benefit to large technology companies, galleries, libraries, educational institutions, and archives that often deal with copyright issues in bulk. It could also potentially benefit a large range of smaller content creators who routinely rely on existing material. So in research terms, by generating new knowledge, particularly relevant to the first rules as code approach, we can contribute, or we aim to contribute, to the rules as code movement more broadly. So we conducted this experiment over a 2-week period in late 2020. The population for this experiment was the pool of legally trained research assistants attached to the broader research project. So in this preliminary study, we had 3 participants in total, and I'll call these participants P1, P2, and P3 throughout this presentation. So in week 2, or phase 1, the participants independently coded sections 40, 41, 41A and 42 of the Copyright Act, which are among several fair dealing exceptions to copyright infringement. So these exceptions are those for the purpose of research or study, criticism or review, parody or satire, and reporting the news respectively. So by independent coding, we mean that participants work in remote coding files rather than the project's shared GitHub repository. Additionally, we instructed participants to assume that the elements for determining whether copyright subsists in a work are satisfied. So we asked them to assume copyright subsistence and to encode the select legislative provisions only. So this means they did not encode the relevant case law, and this was largely due to time constraints. In week 2, or phase 2, participants encoded sections 31, 32, and 36 of the Copyright Act. These provisions outline the nature of copyright in original works in which copyright subsists, and infringement by doing acts comprised in the copyright, respectively. So like in week 1, participants encoded the select provisions only, so they didn't encode the case law. Aside from participants encoding different provisions in each phase or each week, which was a choice that we made largely to avoid participants becoming overly familiar with the statutory text, the main difference between the 2 phases is that week 2 had an intervention, a 2-hour compulsory meeting during which participants collaboratively drafted key atoms or legal terms for manual coding, and they did this in a single remote atom or coding file. The agreed atom file was separate from our other established coding conventions, and after this meeting, participants independently coded the select provisions like in week 1. And participants could refer back to, but they couldn't edit those agreed atoms. So the purpose of this intervention was to test our hypothesis that coders collaboratively agreeing on key atoms or legal terms before commencing independent coding work can increase the similarity of their coded output. And our null hypothesis was the opposite. So to convert select provisions of the Copyright Act into machine executable code, participants used the coding language turnip, which coders can run via the online environment turnip box as shown on the top right-hand side of the screen. As I'm sure that many of you might know, turnip is a programming implementation of defeasible deontic logic, which our collaborator, Professor Guido Governatori, will explain in the next presentation. So I'm not going to go into these technical specifics here. But suffice it to say that we adopted this language because it's particularly useful for coders attempting to express complex rule structures, and in particular, it enables coders to model deontic concepts such as obligations, permissions, prohibitions, and exemptions, which are often present in legislation and were present in the Copyright Act. Also, defeasible deontic logic has been applied in several studies that aim to convert different types of Australian regulation into computer code, and some of those are listed on the screen there. I also wanted to flag that earlier this year, Guido and I put together a masterclass that outlines some of these technical specifics in more detail, and that masterclass you can find on YouTube, as you can see there on the screen. So an important part of this experiment and our methodology for converting legislation into machine executable code more broadly is measuring the accuracy of encoded rules in terms of coding validation and what we call legal alignment. Now, these processes are distinct, but both critically important in our view in enhancing the accuracy of encoded rules. So coding validation on the one hand focuses on whether encoded rules adhere in a formal sense to the select coding language and relevant coding conventions. In practical terms, this means that the code runs and it produces a definitive outcome. Coding validation is also concerned with the degree of internal consistency between coders to ensure that the various encoded rules work together as a cohesive whole. Our coding validation processes involved automated and manual analyses of encoded rules. For automated analysis, we created a program that uses string manipulation to parse each participant's atoms into string arrays and then compare the participants' encoded rules to find similarities between their approaches. We also manually cleaned some aspects of the participants' coding files to attempt to enhance the comparability of their rules. For example, we adjusted some atom names, which used a mixture of periods and camel case in line with our project-specific naming conventions. On the other hand, legal alignment is concerned with enhancing the congruence between the encoded rules and the true meaning of the select regulation, for example, legislation. And this is an undertaking that heavily relies on human judgment. Our legal alignment process is based on what's called the modern approach to statutory interpretation, and it incorporates the turnip coding language. So a good question here is, why do we conceptualize legal alignment in terms of the modern approach? Well, the modern approach is the interpretive approach currently favoured by Australian courts. In the Australian legal system, the challenge of enhancing legal accuracy of encoded rules, as I mentioned earlier, is made more complex by the strict separation of judicial, legislative, and executive powers in the Constitution, under which only the judiciary can authoritatively interpret the meaning of statutes. So the separation of powers, of course, is not unique to Australia, but the Australian courts have adopted a fairly strict approach, and therefore it's best practice for interpreters, including those attempting to do the conversion work like we did, to adopt this approach and apply it from day one. So as you can see on the screen, Project Blue Sky and Australian Broadcasting Authority provides the leading articulation of the modern approach, which is expressed in very clear terms there on the screen. To summarise, this modern approach requires an interpreter to analyse the text, that is the statutory text, the context of the legislation, and the purpose or the policy of the legislation that they're seeking to encode. And most importantly, this approach has taken courts in Australia away from the previous literal or so-called objective or plain meaning approach to interpretation in favour of a more nuanced contextual approach to statutory interpretation. So what we ended up with is a 7-step legal alignment process, as you can see on the screen, that fuses the modern approach to statutory interpretation with Turnip. Now, these seven steps, we don't have time to go through all of these in specific detail, but suffice it to say, as you can see on the screen, step 1 starts with the text, step 2 goes to the context of the legislation, step 3, interpreters consider Parliament's purpose in enacting the legislation, step 4 is where interpreters evaluate the interpretive choices, step 5, where you consider canons of construction, including syntactical and statutory, canons of construction, which help coders address ambiguities in the text. Step 6, coders return to the provision and start the manual conversion work. And in step 7, coders undertake acceptance testing of encoded provisions. Now, if you'd like to see this, of course, in more detail, please do take a look at our paper. Now, in general, we argue that the 7-step process provides a very useful guiding framework that is adaptable and overall can enhance the accuracy of encoded rules. Now, before I delve into our results, of course, there are several limitations that we need to keep in mind, but in the interest of time, I'll just say that the foremost limitation, of course, is our limited number of participants, but we will be addressing this with further research that expands upon this experiment. So overall, the results of our automated analysis show a significant increase in the similarity of atoms and shared rules drafted by participants after the week 2 intervention, as illustrated in Table 1. More specifically, in Table 2, you can see that the similarity of atoms increased from an average of 4.7% in Phase 1 to 57% in Phase 2. The similarity of rules drafted by participants also increased, albeit marginally, from 0% in Phase 1 to 1% in Phase 2. Now, these results overall support our hypothesis that participants agreeing on key atoms or legal terms before commencing individual coding work can increase the similarity of their encoding choices. And importantly, as individual participants encoded different statutory provisions in weeks 1 and 2, this cannot simply be attributed to coders' increasing familiarity with the statutory text. So despite these notable increases in the similarity of atoms and rules from week 1 to week 2, the results show that participants continued to make a range of divergent interpretive choices, for which there are 3 main explanations. The first is the relative difficulty of applying the modern approach to statutory interpretation, which, as previously explained, involves deriving the meaning of a text from close examination of the statute, context, and the purpose. As the Honourable Justice Michael Kirby, a former Justice of the Australian High Court, contends, the task of construing statutory language is notorious for generating opposing answers, none of which are indisputably correct unless the courts have reached definitive conclusions about, for instance, what different provisions mean and how they apply in different cases. So given the potential margin for error in interpreting the meaning of statutory language, it's unsurprising that there were still differences in the encoder's interpretive choices. So second, we also observed that participants encoded the select provisions with varying levels of granularity. And by granularity, we mean the extent to which coders split or broke down the statutory text into discrete parts. So take, for example, the atoms on the top right-hand side of the screen that participants created for Section 40 of the Copyright Act that establishes a fair dealing exception to copyright infringement for the purposes of research or study. So here you can see that P1 or participant 1 adopted a high-level approach that combines research and study into one atom, while P3 uses multiple fine-grained atoms that distinguish between research or study. So in general, we advocate for a more fine-grained approach that provides as much detail as possible as you can see in P3's approach there. But as the results illustrate, participants, despite being from the same team, adopted different levels of granularity. Now, another possible explanation for the differences that we observed is that coders can use the turn-up language in different ways to achieve the same outcomes. So an interesting example comes from week 2 of the experiment, where participants encoded section 31(1)(c) of the Copyright Act on the bottom right-hand side of the screen. So this provision establishes that copyright in a literary work, a musical or dramatic work, is an exclusive right to enter into commercial arrangements in respect to the works that are created. And the select encoding for the provisions are in table 3 there on the screen. So of particular note is how P1 encoded the provision in one rule and dealt with the statutory text other than a computer program using the not operator, which I'm circling there on the screen. P2, however, adopted a more complex approach by creating 3 rules, 2 of which establish the exclusive right not apply to a computer program. So while these approaches are both technically sound or valid when using turn-up syntax as the relevant benchmark, the former is arguably more straightforward. And this example highlights that differences can arise even when coders undertake similar training, they use the same language and work in the same team. So after undertaking automated syntactical analysis, we manually cleaned the dataset to attempt to improve the internal consistency of the encoded rules as part of the coding validation process. And we found that these measures improved the baseline average similarity of atoms from 4% to 39% in week 1, and in week 2 from 57% to 84%. And most notably, coding validation measures significantly improved the average similarity of rules from 0% to 16% in week 1, and in week 2 from 1% to 38% in week 2. So these results underline the importance of shared vocabulary, of shared conventions, but also teams having processes in place for managing alternative, technically sound rule structures with a view to reducing interpretive differences down the line. Now, of course, it's important to note that adopting these different coding validation measures can give rise to certain risks of playing with data, including biases and erroneous outcomes. And these risks lead us to explore the importance of interpreters achieving legal alignment between encoded provisions and the statutory text, to which I'll now turn. So as I mentioned above, legal alignment, as distinct from and in addition to coding validation, is vital for ensuring the accuracy and the legitimacy of encoded legislation. And it is a further step in checking the accuracy of individual coding choices that focuses on our interpretation of the provision using a judicially confirmed process as the basis for interpretation. So here we use the modern approach to statutory interpretation. And critically, it is distinct from a claim of legal validity that the encoded rules are accurately reflect the law. So we aim for legal alignment as opposed to legal validity. So as noted above, participants encoded the select provisions only, mainly due to time constraints, which means that the legal alignment processes were undertaken by the research team after the experiment. And this subsequent legal alignment process highlighted the complexity of attempting to evaluate the extent to which encoded rules align with the languages and logics of a statute. So to illustrate this point, it's useful to return to the encoding choices for Section 40 of the Copyright Act, for which participant 1 adopted a high-level approach and P3, or participant 3, adopted fine-grain atoms. So this provision, which is one of several exceptions for copyright infringement, establishes that copyright in a work or an adaptation of Part 3 works is not infringed by a fair dealing for the purpose of research or study. And the wording of this provision is significant, in particular, legislature's use of research or study. So this raises the question of whether an interpreter should encode terms conjunctively, as in research and study, or disjunctively, as in research or study. So in the case of Degaris there on the screen, Just as Beaumont stated, that terms research and study take their dictionary meanings and most critically should be considered disjunctively. And indeed, the court considered research or study separately. So this suggests that P1's decision to encode the terms in one atom, so as purpose of research or study, risks deviating from the true meaning of statutory text as articulated by the courts. And P3's fine-grained approach to construing the encoding of the statutory language appears to better align with the court's interpretation of the statutory text. And we only gleaned this after undertaking our legal alignment processes based on the modern approach to statutory interpretation.
Ms. Alice, 5 more minutes, please.
Yes. So just wrapping up to ensure that I have enough time for questions. So I wanted to reiterate several key points from our experiment. So the results of our experiment illustrate the complexities of attempting to reproduce the languages and the logics of a statutory text in machine executable format. So while our analyses are preliminary and we have provided a first of its kind experiment that examines how different legally trained people interpret and convert legislation into computer code, what we've done here is illustrate that an intervention like we had in week 2, which was the meeting during which participants collaboratively agreed on key atoms for manual coding, can significantly increase the average similarity of atoms and, to a lesser extent, those rules. So this finding, among others, supports our hypothesis that coders collaboratively agreeing on key atoms before commencing that coding work can be a very useful thing for rules as code teams. And importantly, can enhance overall the technical coding validation, but also the legal alignment of those encoded rules. So despite these similarities, though, we noticed that participants made a range of divergent interpretive choices, which we argue are most likely due to the complexity of statutory interpretation, to encoded provisions having varying levels of granularity or fine-grained detail, and third, the functionality of our coding language turnip. And this underlines that interpretive differences can arise even when coders undertake similar training, use the same language, and also work in the same team. So this further underlines the importance of having established processes and conventions when undertaking this work. And lastly, but most importantly, we contend that rules as code initiatives and teams must ensure that they have processes for both technical coding validation and legal alignment, both of which are critically important in enhancing the accuracy of digitized legislation. And we believe that this is important, particularly in light of well-established statutory interpretation norms and broader public law principles, including the separation of powers. And to ensure that this work is done well, we advocate for multidisciplinary expertise across legal subject matters such as copyright law, statutory interpretation, and technical programming practices. So thank you very much. I'll now hand back to Fernanda.
Thank you very much, Ms. Alice Witt. It was a great speech. Well, we have a question from Hugo Lopez. First, he says that it's a really interesting piece and he thanks you. And I would like to hear your comments from annotators on the understanding of the formal language. Did these influence the annotation process? Did you experience that some parts were different to agree upon?
Yes, we did experience that. And I should say that as part of our coding team, everyone was legally trained, but the team had divergent experiences in computer science, so different levels of experience with undertaking this coding work. And so, yes, there were certainly instances where it was difficult to reconcile some interpretive differences. And what we've taken from this is, number one, the importance of undertaking training with experts like Guido, who was involved in these processes. But also after this experiment, we realized that we needed to further iron out or clarify some of our coding conventions and approaches to enhance accuracy going forward. So I hope that that answered the question, and thank you for that question.
Thank you. Well, if you want to say a few more words, then we go to the next one.
That is only to say that I very much appreciate the opportunity. I did fly through some of those details, so if anyone would like any more, please do read our paper. And if you have any feedback, please feel free to email me at any time.
Okay, thank you very much. Now I'd like to introduce you to Mr. Guido Governatori, who will present the full paper with the title Unreview Legal References in Defeasible Deontic Logic. Thank you very much, Mr. Guido, and the stage is yours.
Do you have my screen?
We had, but not anymore.
Okay.
Okay.
Do you have my screen now?
Yeah.
Okay, thank you. Okay, so this is a joint work in collaboration with Francesco Olivieri at Griffith University. Now, well, this work essentially, it's an extension of what Alice just presented, and essentially it's in the area of computational law. Computational law is at the foundation of what we call the ruler's code, and in our view, computational law is just the use of logic, formal model in particular, to first determine what normative positions or obligations, prohibitions, and permissions are in force in a particular situation. And then after we have what are the requirements, legal requirements in force, we can determine whether they have been violated or complied with. And all of this, it can be done by a machine processable, in a machine processable way. Okay, so that it was my introduction, and then we can go to the actual problem we wanted to address in this presentation and with this paper. Typically, the complexity of legal document, it measures in terms of the length of the document, and it has been argued that the use of references, internal references, or references to other part of document, other part in the same document, or to other documents, it's one way to reduce the complexity of the document because they reduce the length of the document. However, there are several problems. First, when you have references, you introduce a level of opacity because, well, you can just see a reference to a section, but you don't know what the section is about, or you don't know what is the content of that particular sections. And on the other side, if we wanted to encode normative documents, normative systems, taking a ruler's code approach, we have a problem if we use references because they reduce the opportunities to encode or to translate using the isomorphism, the legal isomorphism. The legal isomorphism is that the idea that when you convert a legal document, you want to convert just a part, and when you convert a part and you look at the corresponding encoding, then essentially there are no external dependencies. So if you change text, part of the text in the textual provision, you only have to change the corresponding encoding. But if we have the references and the references must be embedded, then essentially we might lose this correspondence. So, and then essentially here I want to just to give an example of what we mean by legal references. So here I have a few examples. So the important part here is that you can see that there are some references to other clauses. So here, here we have, well, in section 982, we have, well, that's something, it's applicable in section, according to sections 991H, and we have no idea what are those conditions. Similarly, when we look in sections 9.8.2 of the Telecommunications Consumer Protections Code, we can see that there is a reference to something has to comply, somebody has to comply with what's specified in sections 9.9, and then also we will have that there will be exceptions to 9.5, 9.6, 9.7. And when I look here, I have no idea whatsoever on what is the content in 9.9 and 9.5, 9.6, and 9.7. Now, I also have a more interesting case. So when you look here, section 26.105 of the Income Tax Assessment Act, well, as you can see, there are many references. Here we have both external references to a different act. Then we have a bunch of reference where possibly those sections applies in this particular section here. And finally, we have something about failure to comply with another section. So as you can see, references are quite common in legal documents. And if we want to encode those documents in a computer, in a machine executable way, we are able to solve them. Otherwise, we cannot do the encoding and we cannot reason about that. So what is the solutions to do it? Well, the solution is then every time we have a reference, we are going to replace it with its logical representation. So, for example, if we have that section 1 can be encoded if A, B, and C, then D, and we have a section 2 saying, well, if section 1 applies, then E, then what we can do, we can represent section 2 if F, B, and C. So we take essentially the logical representation of section 1, and we replace for section 1, and then we include in the other sections. Now, what we have to understand that when we do this manual process, in many cases, we have to do some logical inferences. So here, well, you can see that, well, I have in parentheses, which might be optional, I don't know, I have and D. So do I have to consider D because it's part of the meaning that section 1 applies or not? And in other cases, I have to do more complex reasoning tasks. Well, our solution is, well, we don't want to use, we don't want to replace with a logical structure, but we want to just represent them. So what we do, we start with the feasible deontic logic, and we extend with reference literals. So we will have expression in the language, such as apply sections, complied sections, violated sections, and then the logic is extended with conditions that allows us to determine when apply sections, comply sections, violated sections hold in a particular situation. And then essentially this is what we're going to do in the rest of the presentation. And then if we take this approach here, what we can do, we can just represent, if we take the previous example, section 2, and then we can write in this way. So apply sections 1, then E. And then essentially, we leave the resolution of this condition, of this norm, to the internals, to the logic itself, and then essentially we don't have to perform as encoder the evaluation manually, but then the evaluations will be done automatically by the system. So here it's just my used cars salesman pitch for the feasible deontic logic. So it's a rule-based non-monotonic formalism. It is efficient, indeed. It has linear complexity. It has a natural directly skeptic semantics. So it means we don't have to compute all possible extensions and take the intersections. We can do the computations directly. And related to this, it has a natural ability to model exceptions in a natural way, in an efficient way. Also, when we consider the extensions with the deontic component, we are able to speak about the deontic aspects, obligations, prohibitions, and permissions, and violations. But at the same time, we can explain the reasoning mechanism of the logic using an argumentation Lacan structures. But at the same time, it has a constructive proof theory. This means that it's fully explainable, and every time I have a conclusion, I can just provide you the full trace of the derivation. I can provide all the facts, all the rules, all the norms that apply, that are used to determine a particular conclusion. We show that other formalism often used in IAAIL law are just variant of the logic and with some differences. And we have used in different fields, and we have a couple of optimize implementation. Alice in the previous presentation discussed Turnip, one of the most modern implementations, though in some way still partial. And also, as Alice mentioned in the presentation, we've used the feasible deontic logic in several exercises, in several massive scale encodings of acts and regulations. Also, it is extensible, which is a part of what I'm going to do today, and essentially the extension is how to do with the legal references. And also, well, as we know, in most cases, deontic representation have suffers from paradoxes, but the feasible deontic logic, for several reasons, something very simple, is not affected by them. So the feasible deontic logic is a combination of diffusible logic, an efficient non-monotonic logic for the representation of the exceptions, plus a deontic logic of violation for the representation of the deontic concept of obligation, prohibitions, and in particular violation. A diffusible theory is the way we structure our knowledge, and essentially it corresponds to a set of facts which will correspond to the facts of a particular case, a set of rules, and the rules will correspond to the encoding of a piece of legislation, and finally a superiority relation. The superiority relation is an internal mechanism to describe the strength, the relative strength of rules in case the rules are for opposite conclusions and they both fire at the same time. So we can determine that one rule overrules or overrides one of the other rules, and then we can discard one of them. It's just what the language we use, so we just have plain literals or atoms in Alice's terminology in the previous presentation. Also, we have deontic operators, so we can say that something is obligatory, or the negation, which corresponds to prohibition, that something is permitted, and so on. But furthermore, we have a compensatory operator represented in this way, and the meaning is that, well, P1 is obligatory, but if it's violated, then the violation makes P2 obligatory, and doing P2 compensate for the violations, and then we can apply for all of them. Furthermore, as I said before, we extended with apply, complied, and violated, where R is just a rule label. Well, so I spoke about rules, and then essentially we have two types of rules, if-then constructions. So here we have what are called constitutive rules. Constitutive rules are rules used to provide definition of terms. And the idea is that, well, when A1 to AN also, when the condition to apply the rule hold, then we produce the effect. For a constitutive rule, we have that we provided the definition of a term, while for a prescriptive rule, we have a similar structure. We use the obligation, and the meaning of prescriptive rule is to generate obligations or prohibitions or permissions. So if A1 to AN are the case, so if they are true or they're all in a particular case, we are allowed to conclude that C1 is obligatory, plus since we might have a longer expression with the compensations, we can apply those operators and so on. Now, here in this case, we can say that if A1 to AN all, then we have that C1 is obligatory. And if it is violated, so if we have the negation of C1, not C1, we have that C2 it's obligatory and it compensates for the violation of C1, etc. And we can repeat for all of them. Okay, so this is a very basic definition of the diffusible logic, of the deontic diffusible logic. And now we can consider what does it mean to reason in the logic itself. Well, if we want to prove a conclusion, then what we have to do is to give an argument for the conclusions we want to prove. But then we have to consider all possible counter arguments against it. And finally, we have to rebut. And we have two ways to rebut a counter argument. Either we can defeat the counter argument by a stronger one, or we can undercut, so we can show that some of the premises do not hold. So the basic construction is that, well, we can say that an argument is a basic fact, or there is a triggered rule for A, and either all the rules for the opposite are discarded, are not applicable or not triggered, and every triggered rule for not A, it's weaker than a triggered rule for A. So the key point to determine what does it mean for a rule to be triggered. So if we have a rule, and it could be either a constitutive or a prescriptive rule, well, the definition of trigger is very, very simple. We need to have that all the elements in the if part in the antecedent A1 to AN are provable, and that is the basic condition. Now we can start to speak and say, okay, now what does it mean for a rule to be applicable? Well, here we have an assumption that essentially a section corresponds to a rule. It's a big assumption, but it's in this stage because when you really model and you encode real life acts in documents, we have that the sections will be encoded by many rules, but we can easily handle and extend to handle those cases. So we can concentrate just to a single rule. Now, here we have two possible interpretations for the meaning of applicable. The first one is that we can say that, well, the rule is applicable, and then in our terms, it also means that, well, the reference applicable are, it's provable, so we can say that it's true. And then the first option is that we just consider the antecedent of the rule, so A1 to AN, so only the condition of applicability. However, if we consider again the first example I gave you, so from the Telecommunications Consumer Protections Code, in that case, a rule is applicable if, well, first of all, the condition, the trigger of the rule applies, so all of them are provable, but also we have that the conclusion, so the effect of the rule, also in this situation, or it's provable. And also we can express that using R. Now, here we have a problem because when we take this definition, we have to consider that might be some rules for the negation. And essentially, we have to incorporate in the proof conditions, in the derivation conditions, how to consider that there might be some possible counter argument for the conclusion and so on. And so essentially, we have to consider those two options to specify when a rule is provable, and in the paper we did it. Now, what about when we move to defining the conditions when a rule is complied with or violated? Well, first of all, the rules must be a prescriptive rule, and then we can say that a rule A1, AN, prescriptive rule C, it's complied with, and then in the simple case, it's simple. We have that the condition to trigger the rule, the condition of applicability also are provable, and then since we want to, it's complied, the meaning of the rule is to produce the obligation of C, and then to comply, we have that also C should be provable. And then when we want to consider it violated, then essentially we have the first condition is the same. We have that we need to be able to prove the obligation of the effect of the conclusion, and also that the opposite of the content of the obligation of the conclusion is provable. Okay, so it seems quite simple. However, what about if we consider this, let's say, this fragment of a license here? So here we have that in some cases, a particular section can include what are the legal requirements, so a prohibition to do something, and then at the same time, they might specify possible way to recover from the violation. So what does it mean to violate or comply with those complex expressions? So when you read this text, it says essentially, well, you have the prohibitions to publish the result of evaluations, but if you publish when you were not allowed, then you have to withdraw within 24 hours. When do we comply? Of course, if we don't publish, we comply. But what about if we publish and we remove it? Do we comply or not? And similar, we can ask the same question for violation. Well, based on these discussions, then essentially we can extend the definitions. And then when instead of a single element in the conclusion of a prescriptive rule, we have a chain considering possible obligation and the possible compensations, then essentially we could have possible meanings. And essentially we have, of course, the rule must be triggered, and then at least the first element must be provable, and additional conditions. In the paper, we really give the proper conditions to specify different alternatives and the different degree of complied with. And similarly, we can do for the notion of provable. Of course, we have to have the opposite, but something more. Okay, so that it was just the idea. So in the paper, essentially, what we did, we studied and defined different types of legal references and how to represent them in the logic. We provide sound and complete algorithm to compute them, and we study the complexity. The key aspect, and well, I don't know whether this is a positive or a negative result, we proved that when we extend the logic with the legal references as presented in this paper, the complexity is still feasible, it's still polynomial, it's quadratic, and then we have an increase because the complexity of the logic when we don't have the references, it's linear. So on one side, we maintain feasible, but we increase, so it's much more. Now, we don't really have any practical experiment to see whether the overhead, the quadratic, the fourth power, it's really a problem or not. I expect probably it might not a serious problem, but it's something we need to study more in the future. So let me go to some possible ideas for future works. Well, we have that references, one of the other possible uses of references is to represent the norm changes. So very often when you want to modify some norms, you specify a reference and how to modify in the particular reference. And in the past, we use nested rules to model norm changes. So what we want to do, we want to extend the framework to model norm changes. And in a couple of months ago, we had another paper where we extended the feasible logic and the computational model of the feasible logic to handle nested rules. So what we want to do is to integrate the algorithms and the computational model presented here with the model for nested norms. Then I said, well, that in real life norms, what you have to do is to consider how to handle set of rules instead of single rules, because, well, often sections references will be modeled as sections will be represented by a set of rules instead of single rule. And at the same time, we want to have an optimized implementation. Unfortunately, for some, well, unfortunate reason that, well, the Data 61 terminated research in computational law, it's unlikely that we're going to do in the near future. So, well, thank you very much for your attention, and I'm open for questions. Thank you very much again.
Thank you very much. It was very interesting. We have a question for you from Marcelo Lopes. He's asking, is the model proposed by you efficient for all types of legal references, or is it more efficient for some types and less efficient for others?
Well, based on the results, it doesn't matter the type of references you have. If you have the reference that they speak about apply, complied, and violated, we have that it's still efficient. It's in the fourth power in the size of the theory. I don't expect to be a real problem from practical point of view, because if you really wanted to model the corresponding text and the references by other techniques, you still have to blow up the underlying theory and the underlying set of rules. So my educated guess at this moment, since we haven't done any experiment of this, is that, well, there will not be real differences, and then it is efficient to model all types of legal references.
Okay, thank you very much. Do you like to say a few words before we finish the panel?
No, that's it. Thank you.
So thank you very much for everybody who's watching us and also for the panelists. And now we'll have a short break for 30 minutes. Those who want to meet other participants and exchange experience can access the Gather Town platform for a networking moment. The link is at the OpenFi platform. Thank you very much, and I see you in the next panel.